Hello, everyone, and thank you for joining us. My name is Laurel Page, and I am the Assistant Director of Events at the University of Colorado Boulder's Leeds School of Business. Welcome to our 7th COVID-19 webinar series. These continue to be trying times, and here at CU Boulder, we have gathered our world-renowned faculty and alumni to provide frank and timely insights for life during the COVID-19 pandemic. Today is the final webinar of our 6 webinars in this COVID-19 related webinar series. To view upcoming webinars, please visit colorado.edu/business/alumni. Click the drop-down arrow and click Attend Online Webinars. For today's webinar, we're excited to welcome Jessica Brown and Barbara Grandjean here presenting COVID-19 hot topics for employers in 2021. A few housekeeping items before we begin. First, if you have any questions now or during the presentation that you would like to ask Jessica and Barbara, please send a question through the Q&A interface. We will monitor questions as they are submitted, and Jessica and Barbara will respond to them at the end of the presentation. As a reminder, for optimum audio quality, we do have everyone on mute except for myself and our speakers. If you experience any technical difficulties during the webinar, please notify us through the chat interface and one of our support specialists will touch base. Lastly, a link to access the webinar recording will be sent to all registrants tomorrow, along with a survey link and supplemental resources from today's presentation. Now, I am excited to introduce today's speakers. Jessica Brown is a partner in the Denver office of Gibson, Dunn, and Krutner, and a member of the firm's labor and employment and white-collar defense and investigations practice groups. Ms. Brown advises corporate clients regarding COVID-19 liability risks, workplace vaccination policies, return to work protocols, whistleblower complaints, reductions in force, mandatory arbitrary programs, non-compete agreements, and trade secrecy programs, She also has defended nationwide and statewide class action and individual lawsuits. For example, gender discrimination under the Title IX and failure to compensate workers properly under the Fair Labor Standards Act. She has been ranked by Chambers USA as a leading labor and employment lawyer in Colorado for 16 consecutive years and is currently ranked in 1 band. She also is the president of the Colorado Bar Association. Our next speaker is Barbara Grandjean, and she is a labor employment partner with Husch Blackwell and represents employers inside and outside the courtroom. She consults proactively with employers regarding workplace issues such as hiring, discipline, and terminations, harassment, discrimination, and retaliation, privacy and social media, medical and non-medical leave, reductions in force, executive employment, wage and hour matters, drug testing and cannabis, and employment handbooks, policies, and training. Welcome, Jessica and Barbara, and thank you so much for being here. I'm going to hand the webinar.
I don't have volume, I don't think. Can you hear me? Barbara, can you hear me?
Mm-hmm.
Okay.
I can hear you too, Jessica. You sound
good. Okay, great. For some reason, the volume cut out for just a moment, I thought. So, well, thank you so much, Laurel, for having us. We really appreciate being here. Excited to be closing out this series relating to COVID-19. I am going to talk about vaccination issues. I wrote a playbook along with a couple of my colleagues back in December, and it was a playbook for employers regarding handling vaccination issues and whether to make vaccination mandatory, whether to encourage, and what some of the legal considerations are that come into play when making those decisions. This slide is just a fun slide showing the very first nurse to receive the COVID-19 vaccine. So we've captioned this sort of the end of the beginning of COVID-19. Obviously, we are not yet to the end of the virus and the pandemic, unfortunately. All right. There we go. The vaccines have indeed arrived. Many of you probably know people who've been vaccinated. Some of you may already have been vaccinated yourselves. The efficacy rate of these vaccines is quite high. They have been approved for emergency use. I'll talk a little bit about that in a moment. The Pfizer and Moderna vaccines, of course, are 2-dose delivery. The Johnson and Johnson vaccine that we're anticipating will be approved, but not before February 26th, is a 1-dose delivery. And you can see here some of the projections in terms of how many people we should have vaccinated before too long. These vaccines have not arrived a moment too soon. Unfortunately, COVID-19 deaths are above what they were last spring. We're doing pretty well, especially in Colorado right now. We pay close attention in my house to the positivity rates, both in the state and in Denver, and they're quite good, relatively speaking, at the moment. But you've probably heard public health experts predicting a spike in March and April due to the variants, which I think, you know, although it's unclear to some degree how effective the vaccines will be as against the variants, particularly the South African variant, it nevertheless makes the process of rolling the vaccine out even more important in some sense, because we are not through dealing with this pandemic, as I noted. All right, so what is the most frequently asked question, at least for a while, that I was getting from employers? What are other employers doing? So some are considering mandating the vaccine, some already have, or conditional mandates, which is, you know, in order to come back to work, or in order to travel, or in order to participate in company functions, then you would need to be vaccinated. So mandates or conditional mandates are one approach. Another approach that many employers are considering is encouragement, ranging from persuasion campaigns all the way up to incentives. And we'll talk about what that looks like. Some are considering making vaccines available on site. And many are just taking a wait and see approach, because vaccination is still not widely available to all workers because of the prioritization that's occurring among the states. Can employers mandate COVID-19 vaccination? Another very frequently asked question. We think the answer is yes. On December 16th, the EEOC issued guidance indicating that employers can mandate vaccination. That is subject to the requirement that people must be accommodated if they have a sincerely held religious belief that prohibits them from being vaccinated, or medical reasons why they can't be vaccinated. So there is a requirement of reasonable accommodation, but subject to those requirements, the EEOC has indicated that yes, employers can mandate vaccination for their employees. Can employees be terminated then if they refuse to be vaccinated? The answer there is not quite as clear. The EEOC basically says maybe. If an employee can't be vaccinated and no reasonable accommodation is possible, then the EEOC says it would be lawful for the employer to exclude the employee from the workplace. That's a little bit different from firing them. And the EEOC would say you need to look at your other policies. You need to look at other leave laws. Maybe you need to look at a collective bargaining agreement, or contracts that certain employees may have with the company to determine whether they can be fired at that point, but they can be excluded from the workplace if they can't be vaccinated, and they would otherwise pose a direct threat. The EEOC has basically said that, that COVID-19 poses a direct threat to the workplace, and that is the reason why it is okay to mandate vaccination if an employer determines that it's suitable for the workplace. What we think is, well, I'll get to that. We'll keep going with the slides. Can employers make COVID-19 vaccination a condition of employment pre-hire? Again, we think so. Again, though, it has to be subject to reasonable accommodation obligations under the ADA and Title VII. And the wrinkle here is that employers can't ask disability-related inquiries prior to hire. So probably the best approach here would be, if you're hiring for a particular position where you want the applicants to be vaccinated, you would let them know that vaccination is a requirement of the job. And then you would also let them know that if they need an accommodation, that they should not let you know that until they receive a conditional offer. At the point that they receive a conditional offer, if they let you know, well, okay, I'm the preferred candidate. However, I can't be vaccinated because I have an allergy, a severe allergy to a component of the vaccine. And so I need a reasonable accommodation. At that point, you could have that discussion. You're allowed to ask medical inquiries in order to determine if an employee can perform the essential functions of the job, either with or without a reasonable accommodation. And so it's a little extra hurdle in the pre-hire context in order to ensure that people are vaccinated when they start. And for some positions, you may find there is a way to accommodate, and in others, you may find there is no way. And at that point, you would be able to retract the offer, but you got to explore whether a reasonable accommodation is possible pursuant to the ADA, the Americans with Disabilities Act, or Title VII for religious accommodations. All right, some people have opined that employers can't actually mandate the vaccine because the vaccines have not been approved. They've only been authorized for emergency use. And in fact, there is a statute that indicates that before an emergency use authorization drug is administered, individuals have to be informed that the product is subject to an EUA. They need to be told of the benefits and risks of the product, and then they have to be given the option to accept or refuse administration of the product. So that's true. That's basically an informed consent requirement, and it's a medical requirement. But it does not say that if somebody refuses the vaccine, that employers would be prohibited from taking some sort of employment action. So this really isn't a statute that affects employment rights or how employers operate in the workplace. So it's our position that yes, you have to give, notice, sort of obtain informed consent before administering the vaccine if you, the employer, are doing it or you're contracting with a third party to do so. And at that point, the employee could refuse, certainly. But if they do, and you have a requirement that that individual needs to be vaccinated to perform their job and no accommodation is possible, or maybe they're not entitled to an accommodation, maybe they're not disabled or have a religious belief that prevents them from accepting the vaccine, then at that point you could take an adverse employment action and prohibit them from doing the job, again, subject to any reasonable accommodations that might be required. All right, so we've established that employers can mandate COVID-19 vaccinations, should they? And the lawyerly response, of course, is it depends. Either way, whether employers are going to mandate the vaccine or merely encourage it, they need to build workplace buy-in. So, developing clear workplace communications, explaining why whatever policy the employer decides to implement makes sense, is good for the workplace. Having those communications is really important. We have a link here to a University of Michigan website that dispels myths around the vaccine and is really useful, I think, for employers to consider incorporating into some workplace communications. Also a good idea potentially to have a doctor come speak to your workforce about the importance of vaccination and why you are either encouraging or mandating the vaccine for your employees. Tying vaccine requirements to reopening and a return to normal is a good idea, although we won't be able to return to normal immediately. So there shouldn't be any kind of promise that if everybody gets vaccinated, suddenly there's no need for masking, no need for social distancing. For some period of time, those things will continue to be important. But tying the idea to return to normal eventually makes a lot of sense. Employers might want to consider reducing the costs of vaccination, again, whether mandating or not. Employers may want to cover any out-of-pocket costs that employees would incur in being vaccinated. The vaccine, the cost of it is basically covered, but there are some administrative fees that insurance may or may not cover for your workers. And then there are the indirect costs of reducing travel time by having on-site vaccination that would reduce barriers, or potentially giving people paid time off to get the vaccine, or to deal with side effects. And we'll talk a little bit more about those types of incentives. But regardless, you should be prepared for some workplace disagreement and hard conversations. And we've seen polls that indicate that, somewhere around 40% of workers may not be willing to be vaccinated. I think I saw one survey that suggested 38% of workers did not want to be vaccinated, but of that group, 13% said they would if their employers required it. So there are a lot of, there's a lot of anti-vaccination sentiment out there. some, I mean, legitimate, positions on both sides for various reasons. And, a lot of times employees don't want to be told what to do with their bodies. That's sort of understandable to some degree. And so you should be prepared for these difficult conversations if you decide to mandate. But what are some reasons to consider a mandate, or like I said, a conditional mandate where employees, for example, are required to be vaccinated in order to return to work, to the physical workplace together versus working from home? One huge benefit is just public health. Like, given the amount of anti-vaccination sentiment there is, and people's, the politicization of these issues and people's reluctance to be vaccinated, we won't get to herd immunity if people are sort of left to their own devices, according to polling. And so, in order to try to achieve herd immunity, and there's some disagreement about what percentage of the population would need to be vaccinated, but I think the latest figures are between 70 and 85%, pretty high. Given that, we may not get there if private employers aren't willing to mandate vaccination. Protecting worker health, of course, is also another reason to do it. And reducing the cost of absences or the need to shut down because there's been a COVID case within the workplace, which of course results in lost productivity. So getting and staying open. Those are all reasons that some employers are considering mandating the vaccine. Reducing civil liability risk. If an employee contracts COVID-19 and can demonstrate that they got it at work, then workers' comp should come into play there. But if customer or other third party contracts COVID-19 and can demonstrate that they got it because your workplace wasn't up to snuff in terms of protections, with masking and social distancing and potentially vaccination, then there is a civil liability risk in that circumstance. In general, we're not so confident that waivers and so forth will be upheld. So that would be another reason to consider mandating vaccination. I think it's going to be very industry specific. I'm aware of a client that their business is driving older people and sick people to their doctor's appointments. Well, if I were their customer, I would want my driver to be vaccinated. Those are close quarters. So that might be an industry where mandating that employees get vaccinated makes a lot of sense. And then there will be others where it really doesn't make so much sense. But these are reasons to consider mandating. And the last item here on the slide talks about OSHA, which has not come out yet and said that any particular industries or employers need to mandate that their employees are vaccinated, but it's possible they will. With the Biden administration, that makes it more likely than less that OSHA would either come out and say there needs to be a mandate, or would cite an employer as having violated the general duty clause if they don't. What might a conditional mandate look like? I've mentioned this. The law firm Davis Wright Tremaine, which is a Seattle-based law firm, quite large, has come out and said they will be requiring proof of vaccination before people can return to the office or attend firm events. And so, they're the only law firm I'm aware of that has already made this pronouncement, and I suspect most law firms probably won't mandate vaccination. But this is one that has said we're going to do that, and their rationale, the managing partner's rationale, is to safeguard the health of our employees and their families, as well as clients and visitors and communities. All right. We talked about accommodations. If you are going to mandate, even if it's just a conditional mandate, if you're going to mandate vaccination for any purpose with respect to your employees, then you are going to have to comply with, as I mentioned earlier, the ADA and Title VII and their religious accommodation obligations. So just a couple notes here. Most employers already have procedures in place for reasonable accommodation because people have medical issues and they need accommodations to allow them to perform the essential functions of their jobs apart from COVID-19. But the reasonable accommodation requirement is an obligation to allow somebody flexibility with regard to a workplace policy if it doesn't impose an undue hardship on the workplace. To the extent for example, though, that you've had employees who are working very successfully from home, and then you try to impose a mandate, to the extent that they've already been doing it successfully, and it might be difficult to show an undue hardship on the workplace to allow them to continue working from home. But that said, employees are not entitled to the accommodation of their choice. And if you can show that, no, we want you in the office, we need you in the office, we have good business reasons for thinking, you'll be more productive here or something like that. And we can give you a safe space that is protected, removed, sufficiently isolated. We want to have you in the office, and we'll just make sure you have those protections. That might also be a reasonable accommodation. So again, employees not entitled to the accommodation of their choice, but there is a requirement to provide an accommodation if it can be effectuated without imposing an undue hardship on the workplace. What are some reasons to consider a voluntary approach? They relate to what we were just talking about. First of all, employee morale and retention. As mentioned, there are going to be people who are adamantly opposed to being vaccinated, and they may bring that sentiment to work if they are obligated to be vaccinated. And then you also avoid the administrative issue of dealing with all these medical and religious accommodation requests. Now, I don't know how many employers will see, but they may see a lot, more than usual for sure. And it could be pretty burdensome to have to deal with them. I don't think you can do a lot to question whether somebody has a sincerely held religious belief. For example, if they're willing to come out and say that they have a sincerely held religious belief or practice that prevents them from being vaccinated, then you really need to probably move on to talking about reasonable accommodations. The medical reasons, from what I'm seeing, the CDC list of contraindications for the vaccine is quite narrow, quite small. Like I mentioned, the allergies. If somebody has a severe allergy to a component of the vaccine, then you're not going to force them to be vaccinated. But most people who have comorbidities, of course, are being encouraged to be vaccinated. So, we'll see if there really are a lot of legitimate medical reasons why people can't be vaccinated. But again, if somebody can get a doctor's note saying that they have a condition that, maybe it's even anxiety or something similar to that. And if they can get a doctor's note, which they probably can, to say that they shouldn't be vaccinated and that would increase their anxiety as an example, then you are, going to have to look at, is there a reasonable accommodation? Can I let them continue to work from home? Or if that's not feasible because they have to interact directly with customers, can I put them behind plexiglass with a mask? Are there ways that they can perform the essential functions of their job safely without presenting a direct threat to customers or coworkers, but not being vaccinated? And that's just, an inquiry that you'll have to deal with. So if you take a voluntary approach, you don't have to deal with any of that because those individuals clearly won't be vaccinated. And so then you're, not having to worry about accommodations. Another reason to consider a voluntary approach might just be your industry doesn't really necessitate it. Again, in law, we are all working from home. We have been since March 13th in my office, staff and attorneys, and it's working quite well. We have a couple essential workers who perform kind of minimum basic operations who rotate in the office, but most of us are at home and it works. So it's hard for me to imagine that we would end up mandating vaccination. Another idea is that employers might want to encourage the vaccine initially and see if they get sufficient compliance before they mandate. So they might want to move to mandating in the future. Employers can offer incentives, but they need to be a little bit careful about this. The EEOC has proposed some wellness program rules that suggest that offering more than de minimis incentives may create some issues. Nevertheless, a number of companies are already doing this. So as just one example I have here on the screen, Kroger is offering $100 to employees to be vaccinated. A hospital in Houston offered $500 and they got up to 75%. So that suggested that the incentives work somewhat. If you assume no more than 60% are willing to be vaccinated, they got up to 75% there with their $500 incentive. Those are incentives that are more than de minimis. So there is some legal risk. I think it's probably relatively small. There are employer groups, though, that are urging the EEOC to come out and address incentives directly because their December 16th guidance that I mentioned earlier does not do that. And it would be really helpful, I think, if they could come out and say that incentives are appropriate in this context. The only other issue to worry about then, though, is whether you're offering an alternative incentive to people who legitimately cannot be vaccinated. Kroger's is offering the $100 bonus to employees who can't be vaccinated legitimately, but who complete rather a training course, a safety training course regarding COVID. Should employers offer vaccines on site? I mentioned this as a way to reduce barriers, but if you're going to offer it on site and mandate, you have to be very careful about collecting information in response to the pre-screening questions. The EEOC has said it's fine to ask for proof of vaccination, but you cannot ask the pre-screen questions without potentially eliciting information that's prohibited to ask about unless it's consistent with business necessity. And so that's just an issue to be mindful of. I think it's great to offer vaccination on site if you can get it. I mean, employers may not even be able to get a large enough supply at this point to do it, but down the road that might be possible. I think you'll want to be wary about both mandating and providing on site for the reasons stated on this slide. If you are collecting personal medical information because you're either administering the vaccine directly or contracting with a third party provider who is doing it on your behalf, then you do have to worry about these kinds of considerations, making sure that, again, the health questions are job related and consistent with business necessity, and that you are not doing anything that you don't have permission, at least tacit permission from the employees to do in terms of sharing that information. So there are data privacy considerations, especially in California, to consider in this context. So you'll want to consult, obviously, with an attorney before administering the vaccine, and particularly if you're going to require it. When can employers stop requiring masks? As I mentioned earlier, not yet. Unfortunately, we still have variants. We know that even as against the non-variants, the vaccines are not 100% effective. They're quite effective. They're very good, but not everybody will be insulated. But then there always will be those individuals who can't be vaccinated. So we are recommending that everybody understand that it's going to take some time still. We're not out of the woods yet, unfortunately. And even if most of your workforce is vaccinated, you're probably still looking at mask mandates and social distancing. So that's all I had. I'm going to turn it over to Barbara now.
Thank you very much, Jessica. That was a great presentation, and it's really interesting stuff, and amazing how quickly it's changing, and it's hard to keep on top of, but thank you for that. I decided to take it a little bit of a different direction from the vaccines, and I'm still sitting in my dining room at my dining room table more than a year later, and I didn't expect to be here. And I've been thinking a lot about what that means for employers who I think sent workforces home, and then here we are a year later, and are there some things that you should be thinking about if you're one of those employers? So you may recall that it was January 20th of last year when the first case of COVID-19 was confirmed in Washington state. As Jessica mentioned, a lot of the law firms in Denver, at least by mid-March, were sending their employees home. I think a lot of employers that don't have frontline workers began sending their workers home, and I think we all assumed it was going to be relatively temporary. So here we are a year later, and we're still here, and I think there's a lot of talk, at least in the law firm circles, that we're not going back anytime before June, if even then. And so this temporary arrangement has really morphed into a longer term arrangement for many employers. And I think we're going to see that trend continue. And I think a lot of employers are going to start to take advantage of it. So prior to COVID, there were about 10% of the American workforce that worked remotely. Sometimes it was an accommodation under the ADA. Many times it was a perk offered by tech companies. But consulting firms are now forecasting that about 1/3 of the businesses expect that 50% or more of their employees are going to continue to work remotely, even once the COVID-19 threat is under control. So I wanted to start my part of the presentation just by doing some unofficial benchmarking from our audience. Okay, so we have a poll question. And so the poll question is, if you're an employer, which of the following best describes your industry? Real estate, manufacturing, academia, energy, insurance, finance or legal, healthcare, information, technology, retail, or other. So we'll give it just a minute here to let you finish the polling. Okay, thank you, Megan. It looks like our poll results, we have most folks from academia on the call. Otherwise, it looks like we have a pretty good representation of all of the other industries. But academia being an interesting one, because my guess is that, similar to law firms, is one that is very likely to have a lot of a virtual or work from home presence as we go forward. So second poll question. If you sent employees to work from home during the pandemic, once conditions improve, what are your plans? First one, everyone back to the office. In-person interaction is critical to building a team. We're still going to have some work from home, but it's going to be a limited basis. We loved it. We're going to terminate our office lease and we're going completely remote, no more office, and we're still thinking about it. So we'll give that just a minute to finish. Okay, it looks like the majority of our audience is planning to have some work from home continue, whether it's segments of the business or certain individuals or certain positions. It looks like it's here to stay. And my guess is, again, we have 68% of our audience saying that, and that's even more than the consultants are really suggesting. So I think we're going to see this being more and more popular. So if we can go to our third poll question. If you sent employees to work from home during the pandemic, did you put any limitations on what states they could work in? And I mean geographic states, not like mental or emotional states. So no, it doesn't matter so long as they get their work done. No, because we thought it was temporary. We're revisiting our decision now. Yes, we needed to make sure that they could report to a physical location like an office or a customer site in a reasonable amount of time if they were called in, or otherwise none of the above. Okay, good news for me, the majority of this group says no, they don't care where their employees are working as long as they get their work done. So they could basically pack up their laptop and move to Florida for the duration, and the 61% of the employers on this call would be okay with that, which is great because it means that you'll be interested in my presentation. So why should you care about any of this? And the first reason, and it really goes to that 61% of the people that just said that they don't really care where their employees are working. You need to be aware that the applicable law that relates to the employment relationship with that employee is very likely to depend on where the employee is working and not where the employer is located. And I think employers are sometimes surprised to learn that. Now, multi-state employers spend a lot of time trying to figure out how to have employment policies that are generally consistent across their workforce, but comply with basically the most employee protective law. So they don't have to have 50 different handbooks for their workforce. And often it's California that employers end up doing because California is the most protective. And so if you make your workplace policies consistent with what California requires, then you're good. But what happens when during this COVID time or after one of your employees decided to rent a beach house and move to Florida to work? Or even better, you know, one of you're a Missouri-based company and your employee decided to move her family out here to Steamboat to enjoy the ski season and work out there, since it doesn't really matter where they're working. I think that you would be surprised if you're that Missouri employer, because Colorado is one of those states that's going to catch employers off guard if they don't know what state their employees are actually working in, or if they're not attempting to control it. So Colorado, for example, has a new paid sick leave law that applies to any employee who is working here. And at this point, there's not a distinction being made by our division, the Department of Labor and Employment, about whether someone is working here temporarily or otherwise. And I think the question of temporary is also up in the air, given that we're, you know, more than a year into working from home. So at what point does it stop becoming temporary? So if you have an employee who's decided to move to Steamboat and work for the ski season, that person is very likely entitled to paid sick leave under Colorado's paid sick leave law. And you as a Missouri employer might not realize that. Similarly, again, talking about Colorado, which is starting to look a little bit more like California, we have new equal pay and transparency laws. And so any employer that has even a single employee working in Colorado, and that could be your remote person spending the winter in Steamboat, is going to make your employer subject to Colorado's pay transparency laws, at least as those laws are currently written and before we have any court decisions. If you have one person working here, you've got to comply with the pay transparency provisions that require you to post compensation that you're willing to pay for any job in your organization if it is located in Colorado or if it is a remote job. So if you're posting for a remote job, they can work anywhere, and you have one person who's working in Colorado, you've got to put in that job posting how much you're willing to pay. And most private employers don't do that and are surprised to learn that. So some states make a distinction between whether the employer is requiring the employee to work remotely or the employee has chosen to work remotely. So in our scenario, the person in Steamboat, I think, has chosen to work remotely. But if that person decided to go to Montana instead, states like Illinois, Montana, New Hampshire, and California, they have provisions that require employers to reimburse employees for expenses that they incur while they are working. And so if your worker is voluntarily working in Montana, then maybe you don't have to reimburse those expenses. But that's an important distinction to be making. And if you have no idea where your employees are working, you may be surprised by that. If we break that down yet another layer, there are local and municipal laws that can apply to the employment relationship. There are some localities that have their own paid sick leave laws. So if you're the Missouri company and your employee has decided to go work in Duluth, Minnesota, or Chicago or Seattle, you may be incurring paid sick leave liabilities that you were not otherwise planning on having. The next, oops, I did not mean to forward my slide. The next thing to be thinking about if you don't know where your employees are, or to keep in mind with the remote workforce, is that many of the same employment protections that you provide in the workplace still apply if your employee is working from home. So for example, your anti-discrimination and harassment protections still have to be available to somebody working from home. Somebody working from home can still get harassed, whether it's by a third party, whether it's by somebody on email, by video conference. So those don't go away just because your employee is in their home. The ADA is still going to apply to your obligations vis-a-vis remote workers. If someone's working from home and they need a reasonable accommodation in order to be able to perform the essential functions of their job, you've got to engage in the interactive process, even if they're sitting in their own living room doing the work. Another example of this would be safety law. So OSHA does not currently require employers to inspect the work sites that are in an employee's home office. But if you are subject to OSHA's record-keeping requirements, you are very likely still subject to that, even if your workers are remote. And then similarly with workers' compensation, if you have workers who are injured while they are working at home, you may have a workers' compensation injury. And so you need to make sure that if you have no idea where your employee is working from, that your workers' compensation is going to cover them regardless of the state or the jurisdiction that they happen to be in. The third point on this slide is that out of sight, the remote workforce really can create some significant compliance challenges if you're not careful. And so the best example of this, and it's always existed, but I think it's exacerbated with the work from home workforce, is wage and hour law. So to the extent that any of the people that you are having work remotely are non-exempt, overtime eligible, you've got to still make sure you're very carefully tracking hours worked. They're still entitled to their meal periods and their rest breaks, even if they are working from their homes. Working from home is, you're more inclined perhaps to work outside of normal business hours, and someone who is a non-exempt employee must be paid for all hours worked. And you have to be very clear with them that they are reporting all hours worked and what the expectations are if they're working outside of normal business hours. Other compliance risks involve, again, where is your employee working? Is it Starbucks? Is it their home? Is it a ski condo with a bunch of other people? But how are you protecting your privacy, your data, the privacy of your information? What restrictions are you placing on the work from home environment? Is it private or can anybody come in? Is information just laying around? Is their internet access secure? Do they have sufficient and secure access? If not, are you requiring them to get that? And if you are you paying them for it? So there are a whole host of issues that arise by having a remote workforce. And the purpose of this is just to remind you all that it wasn't as easy as just sending everybody home last March to temporarily work from home, because I think it's really morphed into something bigger that employers who are not paying attention or planning for it are going to be surprised. So let's see if I can get to my next slide. What should employers do? The first good thing is that you've listened to our presentation. I think just being aware of the issue and recognizing the issues is the first best step. Secondly, I say plan ahead, but not behind. This is the time that you should be planning ahead. You should be sculpting what you want that remote workforce to look like. What are your plans? How are you going to communicate it? Are you going to have written agreements with people? Are you going to have them sign policies? It's better to be proactive than reactive. And then communicating frequently and following up in writing. Employment lawyers love to say that if it's not in writing, it never happened. So again, we're recommending that your remote workforce sign off on policies and contracts and agreements on what they can and cannot do at work and what your expectations are. A great example of that is I see a lot of employers who send the employees home, they send them home with equipment or information, and then don't really have a plan for what they're going to do if the employee's employment ends and the equipment or the information doesn't find its way back to the employer. You can't just automatically dock their pay. Many states and jurisdictions require you to have a written agreement that allows you to subtract the value of that equipment from pay. And so that's something that you've got to plan ahead for and have in writing. And so that's just one example there. Finally, I say seek expert advice, and that's not just a plug for Jessica and I. What that is, it is, but it's also a plug for your financial or tax advisor, because one thing that we haven't discussed and that I'm not going to talk about today because I'm not an expert, but you can certainly have tax issues when your employees are working someplace other than where they're supposed to be. Those are state and municipal tax issues. Different states and different municipalities have different tests on when an employer has a nexus to a state and has to pay the taxes. The time, the length, or the duration that the employee is working there varies by state and by location. And I think now that people have been working for a year or more, you may very likely find yourself subject to tax liability in other states. And if you don't know where your employees are working, you don't even know what that liability is. So the tax professional is also somebody that you're going to want to make sure that you're consulting for your work at home program. And then finally, for me, I co-authored a compliance guide that addresses some of these same issues, but it raises other considerations and other things to think about. And that may help you as you're planning, hopefully proactively, for continuing to have a remote workforce. And so with that, I think we have left enough time for questions. And Laurel, if you'd like to help us with that, that would be great.
Thank you, Barbara and Jessica. As stated before, if you have any questions, please submit them through our Q&A interface so that we can capture those and direct them to Jessica and Barbara. Our first question today is, what is the employer's liability under Proposition 118 if the employee becomes sick after refusing to wear a mask? Barbara, do you want to take this one?
Sure. So Proposition 118 was passed by the Colorado voters last year, and that's the paid family and medical leave insurance program that the state is going to be putting into place. And so it actually doesn't go live, I think, until January of 2024. So the answer to that question is there's no impact today. If you have somebody who gets sick because they don't wear a mask, I think you probably do need to be thinking about Colorado's Healthy Families and Workplaces Act that requires employers to provide public health emergency paid sick leave to their workforce starting January 1 of 2021. And to my knowledge, there's no exception to paying sick leave if somebody decides they're not going to wear a mask and they get sick. You don't get to make that decision. If they get sick and it's a public health emergency related reason, you have to provide them with a certain amount of paid sick leave under the Healthy Families Law.
Right. I think your only remedy for the person refusing to wear a mask, if they were instructed to do so, is just discipline separately. I think you could obviously issue them a warning, that they need to follow work rules. But just like in the wage and hour context, if people work overtime, but they're not supposed to, they still have to get paid overtime. You can discipline them for working overtime when they weren't supposed to, but you still have to pay them.
Great, thank you. Our next question comes from Jeff. Are you aware of any cases where the employee has been able to prove that he or she was infected with COVID-19 at work? Jessica, do you want to take this one?
Yeah, I do. That's a good question. And it does point to an important issue, which is that it is difficult to establish that the place you contracted COVID is work. I think some have probably done it. There can be sort of circumstantial evidence where a group of workers together, all come down with COVID. I think it would be possible to prove it in that situation. But the point is, it is hard to say, I got this at work versus at the grocery store, if you're still going there, or some other location, or from somebody coming into your home, that sort of thing. And because of that, certain states, starting with Illinois, but quite a few others, I don't think Colorado is one of them, but I'm not certain, have enacted presumptions. So under their workers' comp laws, there is a presumption in a number of states that if you come down with COVID and you're going to work, that you contracted it at work. I think it generally only applies to essential workers, frontline workers. This was a development early on in, during the pandemic last early spring, where a number of states were enacting laws to make it easier for workers to say that they contracted COVID at work, and then to have workers' comp benefits apply. So it's a good question. It's a challenge to show that it was at work, but there are ways to do it.
And Colorado has not enacted that presumption.
Yeah. I knew they hadn't, but that reminds me of just a general caveat to everything we're saying, that this is just such a fluid area. And so you just want to really keep up with, developments. Everything we've said today probably is subject to change, because there are so many changes. And of course, with the Biden administration, there will be more changes, new policies and so forth. But this is an area where local law also is really important, state law, and even executive orders and cities, municipalities enacting laws that apply here. So lots to keep an eye on.
Thank you. Our next question comes from Janelle. Can you speak to any additional precautions that should be taken for healthcare workers working from home and providing telehealth from home? Barbara, do you want to take this one? I think alluding to your point on security and privacy.
Yeah, that's what I jumped to was, regulatory and privacy related issues in the telehealth space. And so, to me, that's probably as significant, if not more, for the employers employing those kinds of workers. Because that's where the real liability is going to be if the security, the privacy, and the regulatory things aren't being followed properly, a little bit more so than like the wage and hour, for example, that I mentioned. So I think those are probably the two primary considerations.
Great. Thank you, Barbara. Our next question is, what are the legal implications of trying to conduct contact tracing in the workplace?
Yeah, we talked a little bit about this because that was a pre-submitted question, and the main issues that come to mind there also are privacy related and confidentiality related, and also with vaccines. It's important to remember that even though the EEOC has said that asking somebody for proof of vaccination status is not a medical inquiry, these are health related issues. And so it is important to maintain confidentiality. So, if you do get proof of vaccination from an employee, keep that information separate from the personnel file, keep it confidential, share on a need to know basis, and not more broadly. And the same is true with respect to contact tracing. It's important, I think, for employers to track who's in the office, who's potentially been exposed if a worker comes down with the virus. Just as an example, in our workplace, we did have somebody in the office. We're working remotely, but when the restrictions were lessened, we allowed people to go in on a voluntary basis as long as the numbers didn't get too high. And somebody came to work and after they left work, started coughing. They were actually at the grocery store at the time, started coughing, started feeling unwell. Turned out they did have COVID. And so we keep track of who else was in the office that day and, talk to that person about who they might have come into contact with, and then called those people. But we still, and even if people can figure out this stuff, you still want to respect confidentiality and privacy. And so we're not sharing names of, who's got COVID. We're not sharing names of who was in close proximity to the person who had COVID. It's all being kept very confidential. And again, some of this stuff people will figure out, but that's different from affirmatively disclosing private information. And you want to be careful and not to do that.
Perfect. Thank you, Jessica. And thank you so much for everyone for joining us for today's presentation. Again, I want to give a big thank you to Jessica and Barbara for this great information. At this time, we invite you to provide your feedback on the webinar by answering the following poll question. On a scale from 1 to 10, how likely are you to recommend this webinar to a friend or other CU Boulder alumni? We thank you in advance for submitting your feedback. As a reminder, all webinar attendees will receive an email tomorrow with a link to the recording of this presentation as well as a survey. To view upcoming webinars as well as previous recordings, please visit our website at www.colorado.edu/business/alumni. Today was our final webinar of this series, and our next series will launch at the beginning of April. In the meantime, have a great rest of your day. Thank you for your time, and go Buffs.